Okay, today we're going to have Pete Hendrickson, our speaker. We should be very fortunate and realize the fortune we have to have Pete living in our backyard. He's known pretty well all over the country. He has an Independence Day celebration every year at his home, and he invites people that have read his book. They come from all over the country to your meeting. We had one from Alaska a year ago. So they come from all over. So he's well known throughout the United States. So it's very, very important that we realize the good fortune we have to have him right here in our neighborhood. So, and I'm also very pleased to have him come and speak here today too. So in appreciation of Pete's great work, let's give Pete a warm welcome.
Thank you very much, and thank you for being here. Today, I'm going to make a presentation on it's an expose of judicial malfeasance, and probably everyone in this room, and perhaps everyone who ends up watching this film, will understand that judicial malfeasance is not a new thing. We've always had it. We don't have saints and angels to pick from when we appoint people to judicial positions, and so inevitably there are those with feet of clay in those roles. However, seldom are the offenses of less than perfect judges as substantial and significant as the ones that we're going to look at today. And in my knowledge, never have they been caught so thoroughly and effectively in the malfeasance as what we're going to take a look at today. So, an expose of judicial and executive fraud in administration of the income tax. The truth, the lies, the reasons, and the bottom line. That's what we're going to be looking at today. We're going to expose some outright judicial falsehoods that appear in actual federal appellate court rulings, in which the courts, in order to make rulings contrary to the Supreme Court's jurisprudence on the subject of the income tax, actually lie about the content of Supreme Court rulings on this subject. And the same thing is repeated by the Internal Revenue Service in its publications and in its behavior in legal contests, as we're going to see. So, over the decades, state and federal tax agencies, with the occasional assistance of some courts, have engaged in a massive subterfuge of misapplying the income tax contrary to the law of the tax as it's written, and contrary to the rulings of the Supreme Court, the court whose rulings effectively constitute the law of the land. They hold the same significance as precedent and as authority over all institutions of government as the Constitution does itself in practical terms. And under our legal system, that's the way we view it. There is nothing that can be said by an appellate court, a tax court, any lower judicial tribunal that matches or overrides the rulings of the Supreme Court. So we can look at the Supreme Court rulings to see what is the status of the law today. And we're going to look at some of those, and we're going to take a look at instances in which lower courts and executive agencies have attempted to evade those rulings. When I say that the lower courts have lied about the Supreme Court rulings on the subject of the tax, I'm not talking about them lying in the sense of interpreting the Supreme Court rulings differently than another court might interpret them, or even disagreeing with the rulings of the court. I'm talking about lower court decisions in which the actual text of the Supreme Court rulings is misstated. It's deliberately misstated, as we'll see. So this is not a casual or inadvertent or unwitting mistake or falsification. This is an outright deliberate falsification, and we're going to take a look at the rulings of these lower courts and the U.S. Internal Revenue Service And we're going to take a look at the harm that's been accomplished by these falsifications. And then we're going to see a little bit about, well, actually we're going to see a lot about what it is that they're trying to conceal with their false statements. Now here's the truth about what the Supreme Court has ruled and what is the standing settled law of the land regarding the nature of the income tax. In 1916, after the 16th Amendment was adopted 3 years previously, a number of challenges had arisen to the implementation of the income tax when it was revived in 1913, promptly upon the adoption of the 16th Amendment. The tax at that time was 51 years old already, but it had been on hiatus. It had been dormant since 1895, when the Supreme Court had ruled in the case of Pollock versus Farmers Loan and Trust that as far as the application to two different things, dividends and rents, the application of the tax caused it to become a property tax rather than an income tax by an argument of resort to the source from which the income was derived. That is, the personal property in the form of stock and in the form of real estate from which rent and dividends were derived. The court said this actually constitutes, for all practical purposes, a tax on those sources rather than the income itself, rather than the activity that produced the taxable activity that produced the gains, and therefore it's a property tax, and therefore it has to be apportioned as a direct tax. That was the reasoning in the Pollock case. 16th Amendment overturns that, and we'll get to that in a moment. So in 1916, this revival of the income tax was challenged by a man named Frank Bruchever, who was a stockholder in the Union Pacific Railroad Company, a railroad which is a national instrumentality in which the dividends from that stock was naturally an excisable gain. Bruchever argued that the 16th Amendment had the effect of creating a direct, non-apportioned tax. That is to say, a tax that functioned as a capitation or other direct tax, and yet wasn't subject to the apportionment rule that applies to all such taxes under the Constitution. The court, in a unanimous decision, disagreed. The Bruchever ruling unambiguously confines the income tax to the objects and administrative rules of an indirect excise tax only. Bruchever holds that the sole purpose and effect of the 16th Amendment is to undo and overrule its conclusion in Pollock versus Farmers Loan and Trust, which I mentioned a moment ago, that a tax on otherwise excise taxable dividends and rent becomes a property tax in those particular instances. Pollock had reasoned that the linkage of dividends and rent to their personal property sources, the stock or the real estate from which they are derived, transforms the income excise on those gains into a property tax on the sources, which therefore requires apportionment. The 16th Amendment, says the Bruchever court, severs or prohibits the source linkage imagined by the Pollock court. This overruling allowed the by then 51-year-old income tax to be revived and to resume application as the excise tax it has always been. Bruchever very expressly rules that the 16th Amendment does not accomplish its task by creating some kind of hybrid tax, which can have the character of a capitation or other direct tax, and yet not be subject to the apportionment rule, a non-apportioned direct tax. This was, in fact, the exact contention of Frank Bruchever, against whom the court ruled, who reasoned from this faulty notion the confused conclusion that the post-amendment revival of the income tax created a constitutional conflict. Here's what the unanimous Supreme Court says, among a lot of other things in what is really a very long, thoughtful, and comprehensive ruling, well worth reading, even though Justice White, Chief Justice White, who wrote it, was a man who was fond of 60-word sentences, and so it's a little bit of a slog to get through it, but nonetheless, good material. Here's what they said. Again, a unanimous Supreme Court. We are of the opinion that the confusion is not inherent, but rather arises from the conclusion that the 16th Amendment provides for a hitherto unknown power of taxation. That is, a power to levy an income tax, which, although direct, should not be subject to the regulation of apportionment applicable to all other direct taxes. And the far-reaching effect of this erroneous assumption, you notice that's in bold, because this is what the court is saying. This is an erroneous assumption. It does not do this. Will be made clear by generalizing the many contentions advanced in argument to support it. Bruchever had argued 15 different approaches in his effort to try and argued that this tax was unconstitutional. And the reason for that was simple. His dividends from his Union Pacific Railroad stock were being taxed before being distributed, and he wanted to stop that. So this was the nature of his argument. So that's Bruchever versus Union Pacific Railroad, 240 U.S. 1 in 1916. The court goes on to point out that the very idea of a non-apportioned direct tax is incoherent because it would cause one provision of the Constitution to destroy another. That is, it would result in bringing the provisions of the amendment, supposedly exempting a direct tax from apportionment, into irreconcilable conflict with the general requirement that all direct taxes be apportioned. Well, note, the 16th Amendment does not repeal the apportionment requirement at all. This result, instead of simplifying the situation and making clear the limitations on the taxing power, which obviously the amendment must have been intended to accomplish, would create radical and destructive changes in our constitutional system and multiply confusion. Again, no ambiguity here. The Supreme Court is being perfectly clear in its language and in what it's saying, and you'll understand my emphasis on that point shortly. The Bruchever Court reiterates its repeated pre-16th Amendment holdings that taxation on income is, in its nature, an excise, entitled to be enforced as such. Okay, this is pretty clear, right? The unanimous Bruchever Court flatly holds that the income tax was, is, and remains an excise tax, and that the 16th Amendment in no way whatever authorizes a non-apportioned direct tax. Okay? Every possible authority agrees, going forward into time, about what the Bruchever Court says. This is Cornell Law Quarterly, 1516 edition. The 16th Amendment, this is analyzing and reporting on the Bruchever decision, which is what the Cornell Law Quarterly was all about. 16th Amendment does not permit a new class of direct tax. The amendment, the Supreme Court said, judged by the purposes for which it was passed, does not treat income taxes as direct taxes, but simply remove the ground which led to their being considered as such in the Pollock case, namely the source of the income. Therefore, they are again to be classified in the class of indirect taxes to which they by nature belong. This is the Harvard Law Review, 1915-1916 edition, on the same subject. In Bruchever versus Union Pacific Railroad Company, Mr. Chief Justice White, upholding the income tax imposed by the Tariff Act of 1913, construed the amendment as a declaration that an income tax is indirect, rather than an exception to the rule that direct taxes must be apportioned. Really clear, yes? Okay, we're going to look at it again. This is the Supreme Court again, later in 1916, after the Bruchever decision, dealing with another case, somewhat related, another tax-related case, saying, by the Bruchever ruling, it was settled that the provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged, and being placed in the category of direct taxation subject to apportionment by a consideration of the sources from which the income was derived. That is, by testing the tax not by what it was, a tax on income, but by a mistaken theory deduced from the origin or source of the income taxed. Here's the Supreme Court again. This is 20 years later, in 1937. If a tax is a direct one, it shall be apportioned according to the census or enumeration.
Pete, could you state the name of the last case and the name of this case just for the recording? Sorry to interrupt.
That's not a problem.
If you have it.
That previous case was Stanton versus Baltic Mining Company, and this current one is Stewart Machine Company versus Collector of Internal Revenue Service.
Thank you.
Again, if a tax is a direct one, it shall be apportioned according to the census or enumeration. Perfect clarity. There are no exceptions to the apportionment rule for a direct tax. And again, this is 20 years after Bruchever. This is the House Congressional Record of March 27, 1943. It's the testimony of former Treasury Department legislative draftsman F. Morse Hubbard. This is the fellow that wrote tax law. The income tax is an excise tax with respect to certain activities and privileges, which is measured by reference to the income which they produce. The income is not the subject of the tax, it is the basis for determining the amount of tax. We'll get to that as the significance of that a little later. The amendment, the 16th Amendment, made it possible to bring investment income within the scope of the general income tax law, but did not change the character of the tax. It is still fundamentally an excise or duty. Again, 1943. 1979, this is a report by Howard M. Zaritsky, the legislative attorney of the American Law Division of the Library of Congress, talking about the Bruchaber decision. The Supreme Court, in a decision written by Chief Justice White, first noticed that the 16th Amendment did not authorize any new type of tax, nor did it repeal or revoke the tax clauses of Article 1 of the Constitution, quoted above. Direct taxes were, notwithstanding the advent of the 16th Amendment, still subject to the rule of apportionment. 1979 now, congressional legislative attorney, specifically declaring that the Bruchaber decision held the tax to be an excise, not a direct non-apportioned tax, and that it ruled that there were no direct non-apportioned taxes of any kind still. 1988, South Carolina versus Baker, the U.S. Supreme Court again. The sole purpose of the 16th Amendment was to remove the apportionment requirement for whichever incomes were otherwise taxable. This is a little bit of a more obscure statement of the same principle. The court is saying that the 16th Amendment did not permit a tax on anything and everything that comes in, on undistinguished revenue. It only applies to things which had already qualified prior to the amendment as subject to that tax.
Okay, so I'm confused.
No, please, Don, I'm sorry, but we're going to do questions afterwards.
All right.
And we'll get to we'll probably find the answer as we go. Okay, summarize. The Supreme Court's words in the Bruchaber, this is what we've seen. The Supreme Court's words in the Bruchaber ruling itself, the 1916 Cornell Law Quarterly and Harvard Law Quarterly reporting on the Bruchaber decision, the Supreme Court referencing and reiterating the Bruchaber ruling in 1916, 1937, and 1988, the Treasury Department's tax legislative draftsman, and the Library of Congress's legislative attorney in 1979 discussing the Bruchaber ruling. All agree that Bruchaber rules the income tax to always have been, and to still remain, an indirect excise tax. That the 16th Amendment does not authorize any kind of non-apportioned direct tax, and that non-apportioned direct taxes remain constitutionally prohibited. Was that clear to everyone as we proceeded? The Bruchaber ruling is the thoroughly settled law of the land. Every institution of government knows that and knows what Bruchaber says. Now, let's take a look at the lies. Despite the absolute clarity of what the Bruchaber court says and what remains the settled law to this day regarding the meaning and effect of the 16th Amendment and the nature of the income tax, in 1980, a federal appellate court makes this bizarre and manifestly false pronouncement. This is the 8th Circuit in United States versus Francisco in 1980, and it says, the income tax is a direct tax. See Bruchaber versus Union Pacific Railroad Company. The purpose of the 16th Amendment was to take the income tax out of the class of excises, duties, and imposts and place it in the class of direct taxes.
That's just the opposite.
It is a lie. It's just simply a flat lie. There is no, this is not a mistake. This is not an error. This is not an oops moment. This was a false statement of what Bruchaber says, which everyone knew was a lie. I mean, everyone except, unfortunately, Francisco or his attorney, because no argument was made afterwards, to my knowledge, that this was a lie, and Francisco suffered harm because of this ruling. In 1984, another federal circuit court, the 5th Circuit in Parker versus Commissioner, says, the Supreme Court promptly determined in Bruchaber versus Union Pacific Railroad Company that the 16th Amendment provided the needed constitutional basis for the imposition of a direct, non-apportioned income tax. For decades, the IRS has published the same lie. This is a portion of an IRS post on their website, and this also the same material appears in many of their printed publications. The law. The courts have both implicitly and explicitly recognized that the 16th Amendment authorizes a non-apportioned direct income tax on United States citizens, and that the federal tax laws as applied are valid. In the United States versus Collins, the court cited Bruchaber versus Union Pacific Railroad and noted that the Supreme Court has recognized that the 16th Amendment authorizes a direct non-apportioned tax upon the United States citizens throughout the nation. In fact, what's actually said by the Collins Court is actually worse even than the little portion that the IRS cites. This is what the Collins Court actually says. For 75 years, the Supreme Court has recognized that the 16th Amendment authorizes a direct non-apportioned tax. See Russiagate versus Union Pacific Railroad. This is insanity. These lies by panels of actual U.S. appellate court judges in actual rulings, by which actual Americans suffered actual and substantial harm, are grossly, egregiously, and staggeringly criminal, and so glaringly false as to raise the specter of dementia. This is the sort of behavior that should land these judges in prison, if not facilities for the criminally insane. These lies are also fundamentally despotic in nature and purpose. This fact is ironically underscored by the 1984 date of the Parker ruling quoted above. Like the other judicial lies about Russiagate and its law of the land ruling concerning the nature of the income tax and the ongoing constitutional prohibition of any kind of non-apportioned direct tax, the Parker Court's falsehood seeks to exploit a dynamic George Orwell insightfully explained in his book 1984. Who controls the past controls the future. Who controls the present controls the past. The object of all the judicial lies is to enable the perpetuation of an ignorance tax scheme by corruptly falsifying history. We're going to get to the nature of that scheme in a moment. All told, the behavior exposed above is nothing less than subversion. These judges and their present-day mimics, co-conspirators, and enablers were and are oath-breaking enemies of the Constitution, engaged in a deliberate and sustained assault on the rule of law in America. The reason for the lies. At this point, you must be wondering just what is going on, and you should. And the reason for all of this is because excise taxes are privilege taxes. What does that mean? Well, as has been shown, the lies by some courts and by the tax agency are meant to hide the fact that the 16th Amendment didn't authorize a non-apportioned direct tax, and that in concert with all other branches of government, the Supreme Court definitively holds that the income tax is an excise tax. The reason they don't want you to know this is because excise taxes are privilege taxes and cannot fall on all that comes in, or in fact on anything that comes in if it doesn't proceed from the exercise of a privilege. To some, this will sound unbelievable. We're going to look at proof in just a moment. But first, I want you to think about this. If what I just said and what I'm just going to show you about excise taxes, or something just as significant, under whatever name, isn't true, why lie about Russiagate? Why would these courts that we just saw lying outright about what the Russiagate court says, why would they do it? There's no reason for them to do it if what Russiagate said actually authorizes what's going on out there today. If it actually authorized what these courts wanted to rule, and what they did rule in those cases, which was that the tax is a tax on whatever, everything that comes in. If you make money, you have to pay the tax. That's what these courts ruled. If that's the case, then why lie about this? The fact is, it is not the case, and that's the reason for the lie. Well, I say the tax exists because of authorization by the 16th Amendment, rather than acknowledge that it was originated in 1862. And was merely resumed in 1913. That was another aspect of the question. That is, if the rules or nature of an excise tax allow for the imposition of a tax the way you experience the income tax today, why try to hide or evade the fact that the Supreme Court says it's an excise? And why lie about its date of origin and about the Supreme Court flatly holding that non-apportioned direct taxes are forbidden? If the fact that the tax is an excise didn't somehow hinder the application of the tax in the way the revenue-hungry government wants to see it applied, there would be no lying. This is clear enough, right? This is just common sense. This is, everything I needed to know I learned in kindergarten level stuff, frankly. Okay, so that was a little bit of preparation against the possibility of brain freeze, because we've all been conditioned to believe all kinds of lies about this subject, about the tax. We've been conditioned, in fact, to believe the tax to be effectively a direct non-apportioned tax. A tax that could be laid right on us for exercising our rights to engage in economic activity, and without any apportionment control whatsoever. So, here are the details about what excise taxes actually are. Supreme Court, again, quoting and reiterating an earlier Supreme Court on the same subject, As was said in the Thomas case, this is Flint versus Stone Tracy, by the way, in 1911. As was said in the Thomas case, 192 U.S. 363, the requirement to pay excise taxes involves the exercise of privileges. Here's the House Congressional Record. This is F. Morris Hubbard again on this subject. We saw this earlier, but now it has context. The income tax is an excise tax with respect to certain activities and privileges, which is measured by reference to the income which they produce. The income is not the subject of the tax, it's the basis for determining the amount of the tax. Excise taxes are taxes on activities. They're not taxes on things, they're not taxes on money, they're not taxes on simply earning money. They're taxes on the exercise of privileged activity. We're going to see more about that in a moment. This is Waters versus Chumley. This is the Court of Appeals of Tennessee on the subject of excise taxes and privilege taxes. Case law recognizes no distinction between a privilege tax and an excise tax. I'm going to skip the citations in this one. Whether the tax be characterized in the statute as a privilege tax or an excise tax is but a choice of synonymous words. For an excise tax is an indirect or privilege tax. The term excise tax and privilege tax are synonymous, and the two are often used interchangeably. The term excise tax is synonymous with privilege tax, and the two have been used interchangeably. What do we mean by privilege? That's a complicated subject in and of itself, but here's an example of the Supreme Court, here's Black's Dictionary giving a definition in general of the privilege concept. Privilege, a particular benefit or advantage enjoyed by a person, company, or class beyond the common advantages of other citizens. An exceptional or extraordinary power of exemption. A particular right, advantage, exemption, power, franchise, or immunity held by a person or class not generally possessed by others. As an example, here's the Supreme Court in United States versus County of Allegheny, 1944, talking about an example of taxable privilege. The government is an abstraction in its possession of property largely constructed. Actual possession and custody of government property nearly always are in someone who is not himself the government, but acts in its behalf and for its purposes. He may be an officer, an agent, or a contractor. His personal advantages from the relationship by way of salary, profit, or beneficial personal use of the property may be taxed. The privilege excise principle is very simple. For the government to be able to charge an indirect, non-apportioned fee or tax for engaging in an activity, the activity must be one done by permission of the government, rather than anything done by right. This makes the things done for which the fee can be charged necessarily and inherently an exercise of privilege. Payment of an excise tax is payment for the privilege of X, in the most basic sense of that expression. The reciprocal, of course, is that such a tax can't apply to things for which you don't need government permission, like trading your labor for pay with anyone except the feds, or engaging in any other economic activity not involving federal stuff. So, simply making money is not a privilege, and the courts are very clear on this. This is the Supreme Court in Butchers Union Company versus Crescent City Company in 1883. The right to follow any of the common occupations of life is an inalienable right. The court also says it has been well said that the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing this strength and dexterity in what manner he thinks proper without injury to his neighbor is a plain violation of this most sacred property. I'm quoting Adam Smith from Wealth of Nations, Book 1, Chapter 10. Smith will come into our story. This is again the Supreme Court in Coppedge versus Kansas in 1915. Included in the right of personal liberty, this is after the 16th Amendment, by the way, not necessarily significant, but I'll point it out anyway. Included in the right of personal liberty and the right of private property, partaking of the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of personal employment by which labor and other services are exchanged for money or other forms of property. A matter of right. This is the Supreme Court of Arkansas in 1925 in Sims v. Arons. And this is a very, very interestingly put quote, and I want you to pay close attention to it. Read it carefully as it goes, and recognize that when this court uses the expression income, it is using the technical legal term income as it is meant in the context of the income tax. It does not mean what Webster's says about it, which is one version or another of all that comes in, and how we use it in common speech. In the context of tax law, income only means the kind of stuff that comes in that governments can tax. Now, here's how this is put, and you'll recognize the significance of that in a moment. The legislature has no power to declare as a privilege and tax for revenue purposes occupations that are of common right. And in this, the Sims Court is simply reiterating what we've just seen the Supreme Court saying over and over again over the decades. If you do it by right, you can't be taxed for it. The right to engage in an employment, to carry on a business, or pursue an occupation or profession not in itself hurtful or conducted in a manner injurious to the public is a common right, which under our Constitution, as construed by all our former decisions, can neither be prohibited nor hampered by laying a tax for state revenue on the occupation, employment, business, or profession. Now, here's the significant little kind of mind-bend portion. Thousands of individuals in this state carry on their occupations as above defined, who derive no income whatever therefrom. Understand the distinction that's being drawn here between income as it is meant in tax law and income as you would think of it in general usage. This court is very, very, very plainly pointing that distinction out. Thousands of individuals in this state carry on their occupations, businesses, professions, employments, who derive no income whatever therefrom. They're getting paid, but they're not getting any income. That's the distinction between income as meant in the law and income as used in common language. But where an income is derived from any occupation, business, profession, or employment, that is to say, where the income as meant here, the income as meant in tax law, is derived from any occupation, business, profession, or employment, then the legislature may lay thereon a tax. Again, drawing that distinction between income as it is meant in tax law, the thing that's taxable, a taxable kind of stuff that comes in, versus the common usage income, where we just think of it as being everything that anybody makes. Okay?
One question, may I?
Go ahead, because this is actually a...
Would that be energy as income, meaning energy as an income?
energy.
Energy, the interest.
I'm not following you.
Some of the income, some of the interest that's created from money is called energy
Okay.
in the IRS codes. Therefore, it's taxable.
Not in IRS codes, it's not. But I believe that it might be in some context, yes. But in and of itself, no. Interest from that is paid from, for instance, a national bank, which is an instrumentality of the federal government, that does qualify as income, yes. So some forms of interest do, absolutely. Okay. All right. And we can come back to this further in the Q&A if necessary, but I hope everyone has taken this in, because it really is a very telling expression. And if this didn't sink in, let it percolate in your mind for a little while. It's very important to recognize the distinction between income in the tax law and income in any other sense. It is by grasping that difference that you'll have the light bulbs go off, and you will suddenly understand the income tax in ways that you never did before. Income in tax law always has quote marks around it. It has the quote marks that these statements by the Arkansas Supreme Court imply, even though they don't include them in the text. They're implying the quotes. This is the special kind of income that we're talking about here, and that's why thousands of people can make lots of money and not have any of it. But if your money does happen to be it, then we can tax it. Okay, that's the distinction being drawn here. This is the Supreme Court of Tennessee in 1960, Jack Coal Company versus Alfred T. McFarland. Since the right to receive commonly defined income or earnings is a right belonging to every person. This right cannot be taxed as privilege. Can't say it any more clearly than that. The privilege element of the income tax is established independently of the legal character of the constraints native to excises as well. We're going to look at another direction in which we can understand the nature of the tax. And again, what we're talking about here is, we're talking about what the income tax actually is. We're talking about what the income tax is within its constitutional parameters and within the parameters of the ruling Supreme Court, the reigning Supreme Court decision on this subject, which is Bruchhaber, and you can know that actually, or settle any doubts about the subject of Bruchhaber being the law of the land on this subject by the very fact that the three appellate courts whose rulings we looked at earlier, that's who they cite to when they lie about the case. If Bruchhaber had ever been overturned or overruled by anyone else, they'd be citing to who that was. And that may have been one that actually said what they say Bruchhaber says, but there are none, and that's why they cite to Bruchhaber. Okay. Privilege element of the income tax is established independently by the legal character and constraints native to excises as well. A tax on or measured by unprivileged receipts is a capitation, which is inherently and constitutionally a direct tax. This is the Supreme Court in Pollock versus Farmers Loan and Trust in 1895, discussing the meaning of capitation. This is in fact possibly the only case, it's the only case I've found, and may very well be the only case in the Supreme Court's jurisprudence, in which the meaning of capitation is actually laid out. Very critical case, and very critical definition. Most people, in fact, most constitutional attorneys even, have no idea what capitation means. They've never seen a ruling, they've never seen this, and therefore they've never seen a ruling that actually explains it. They take it for granted that it has some accounting meaning or something like that. Who knows? But in any event, this is what it actually means. The Supreme Court has said. Albert Gallatin, in his sketch of the finances of the United States, published in November of 1796, said, "The most generally received opinion, however, is that by direct taxes in the Constitution, those are meant which are raised on the capital or revenue of the people." He then quotes from Smith's Wealth of Nations, Adam Smith's Wealth of Nations, and continues, "The remarkable coincidence of the clause of the Constitution with this passage in using the word capitation as a generic expression, including the different species of direct taxes, an acceptation of the word peculiar, it is believed, to Dr. Smith, leaves little doubt that the framers of the one, that is, the framers of the Constitution, had the other, Smith's definition of capitation, in view at the time, and that they, as well as he, by direct taxes meant those paid directly from and falling immediately on the revenue." Adam Smith's Wealth of Nations was a 1776 publication. It was read in huge numbers by the founders, the founding generation. He was effectively the father of modern economics. The founders were avid students of this. He also wrote effectively on legal matters as well throughout the course of his work. And as the court says, and as Gallatin, who was the Secretary of State, a senator, congressman, ambassador to France, I believe. He was the longest running Secretary of the Treasury in U.S. history, I think, still. A very, very impressive resume, astonishing resume, in fact. It says at the time, contemporaneously, that Adam Smith was, in fact, the one who gave the framers the definition of capitation. Here is Adam Smith, the expert source relied on by the framers in their choice of terms of the constitutional taxation provisions, describing some of the tax applications and practices encompassed by capitations, which are also known as poll taxes, by the way, an expression which, in this context, has nothing to do with voting. The taxes which it is intended should fall indifferently upon every different species of revenue, that is to say, just like what we imagine the income tax to be today, right? Falls just on, you make money and there's a tax on it, right? Isn't that the sense that you're led to believe constitutes today's income tax? The taxes which it is intended should fall indifferently upon every different species of revenue are capitation taxes. In the capitation which has been levied in France without any interruption since the beginning of the present century, people are rated according to what is supposed to be their fortune, by an assessment which varies from year to year. In the first poll tax, some were assessed at 3 shillings in the pound of their supposed income. This is Adam Smith from an inquiry into the nature and causes of the wealth of nations. We can't get to the bottom portion of that, but book 4, and I don't recall the chapter, 1776. Here is the definition of capitation from the official law dictionary of Congress when the income tax was enacted in 1862. Capitation, a poll tax, an imposition which is yearly laid on each person according to his estate and ability. That's Bouvier's Law Dictionary, 6th edition, 1856. Capitations and other direct taxes must be apportioned. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration hereinbefore directed to be taken. U.S. Constitution, Article 1, Section 9, Clause 4. And as you will recall from what we looked at when we were looking at the reiterations of the Bruchmer decision earlier on, for instance, in Stewart Machine Company versus Commissioner, we saw that nothing has changed in that rule. Direct taxes remain subject to the apportionment requirement. There is no such thing as a direct tax that can be administered without apportionment. If a tax is administered without apportionment, it cannot be direct. Those two things are married together under the constitutional structure. So we know by these legal facts that the unapportioned income tax cannot, but instead can only concern distinguished revenue, which is to say revenue proceeding from the exercise of privilege, as in all excise taxes. So we come at it from another direction as well to see the definition of what the income tax is actually legally authorized to be. Here's the bottom line. The receipts subject to the federal excise, the income and the federal income tax are those produced through the exercise of certain federal privileges and no others. Just like the name says, it is a federal income tax. It's not a federal income tax like federal tax on all income, federal tax on everything that comes in. It's a tax on federal income, period. If it's not federally connected, it's not income. It's not subject to the tax.
Say what?
Yeah. Is that all? Brian's the only one. Can you give me a say what? Can I get a say what?
Say what?
Because yes, you've been fooled and lied to and screwed. You and your parents and or grandparents, for that matter, back to the early 1940s. That's when the scheme, all the lying is meant to conceal, began in earnest. Only 75 years. Only 75 years. Prior to that time, people knew what the tax fell on. Starting in the 1940s and the tumult of World War II, and after years of the Great Depression and the onslaught of mass media engineering of consent through radio and so forth that Franklin Roosevelt mastered and took huge advantage of, the bulk of young American adults at that point had been through government schools for the first time in our history. A lot of things came together. Donald Duck was in every movie theater urging people to just fill out the tax forms and just don't ask questions. And some other things went on as well, all of which came together in sort of a perfect storm of BS. The matrix settled in place at that point, 75 years ago. That scheme involves tricking Americans into legally characterizing all their payments and receipts as privilege-related and therefore taxable, by reporting them under one label or another as income on tax forms. And I see that slide got messed up a little bit. Sorry about that, folks. The lies about the nature of the tax shield the subterfuge from exposure by obscuring the relevance of the privileged-unprivileged distinction. That's what the courts are trying to fool you with. That's what they're trying. That's what they're lying about. They want you to not understand the privilege component of the tax. The effect of these lies and other crimes in facilitating the revenue and corresponding growth of the state is dramatic, as vividly shown in this graph charting the growth of the federal government. I want you to look at this. This is from 1792 to 2004. This is the size of the federal government over that span. You will see we have an actual hockey stick here. This is not Al Gore's baloney. This is a real hockey stick graph. We have a flat line, virtual flat line, from 1792 to 1943. A virtual flat line. A couple little bumps. There's a little bump here at the war between the states. A little bump for the First World War. And then, starting in 1943, We went from an average tax return completion rate of households across the country of below 9%. That was the average over all of the years of the income tax prior to that time, 80 years. Now, it wasn't applied in all those, I mean, the tax was not collected in all those years. There were a couple of periods where it was dormant. But over the entire span, the average percentage of households in America that were obliged to complete an income tax return was below 9%. By 1945, it was 93%. Anybody remember the constitutional amendment that took place in 1943 that changed everything? No, there was none. The law didn't change, even the exemption rate didn't change. Nothing changed except that perfect storm of obfuscation that I talked about, thanks to World War II going on, Donald Duck making his videos everywhere, his cartoons everywhere, government schools, a drumbeat of, I'm sorry?
The victory tax?
Victory tax was a component. It was one of the ways of slipping the camel's nose under the tent flap. At that point in the 40s, the government suddenly decided, after having passed the Current Tax Payment Act of 1943, which resumed withholding, which had been on hiatus since 1916, and had always been in tax. From 1862 on, the withholding structure was in place. In 1916, they put it in abeyance for a period of time, and in 1943 they revived it under the Current Tax Payment Act of 1943. And when they did that, they instituted a bunch of terminology, a bunch of statutorily defined terms, such as wages, employee, employment, and so forth. Once this act was in place, the government sent tax forms to businesses across the country saying, report all the wages paid to your employees. They didn't include the definitions. They just said, we want you to report all the wages paid to all your employees. And people took these things and, I got 40 employees, I guess I pay them wages. And they wrote it all down and they sent it in and they signed under penalty of perjury saying that's what they had done. They had paid wages to these employees last year. Well, wages was a defined term in the law at that point. Under the Current Tax Payment Act of 1943, it referred to the pay given to people receiving income in the quotes. Government workers, that's what it applied to. That's what wages is defined as. Employees are defined as those workers. And so all of these businesses across the country swore under penalty of perjury that their workforce was employees, made up of employees who were paid wages. And by doing it on that form, they were saying they meant those terms as those terms are defined in the statutes. Not that they had a workforce and that they were, they were a company that had people working for them, and they paid them, which is all they thought they were doing. But what they were actually saying was legally. They were saying we have people who make this privileged type of gains and who act in these privileged capacities. And the government took all this stuff and said, okay, now we're going to send bills out to people, basically. We're going to expect people, we're going to see to it that these copies of these documents that make these statements go to all the individuals involved, and we're going to let them look at them and figure out for themselves that, I guess I have to put this in my tax form, says I have to put down whatever the wages are that are reported over here, so I guess I'll transfer that number, and then I go through the calculations, and it says if I had this much of that, then I have to send a check for this much to Uncle Sam. And that's how it began. And it worked. People fell for it. They're not accustomed to reading the law. They thought their government was a benign, Uncle Sam. I mean, it was looking out for their interests. It wouldn't fool them. It wouldn't
Still
trick them.
do.
Well, many still do. At that time, people were very much viewed things that way. That was the time of FDR and the fireside chats and World War II, where people were saving bacon fat, to send to the troops, and they were not buying tires so that the rubber was free. Many good things, considering the war effort, but they had become acclimated to that level of subordination, of just doing what they were told or doing what they were asked without question, without anything. That period, that generation, and then of course, a lot of people were receiving what qualified as wages too, because we had seen 1 million people go into the armed services at that point, and we had just come out of a period where the works projects were going on, and under the Depression, the New Deal structure. It was a time when all these things just kind of came together and allowed this subterfuge to work, and it did work. And since then, since that period of 1945, when we hit the 93%, we've stayed in the 90s ever since. It never got figured out. The subterfuge was never revealed at that point. Until 2003. And that's the happy ending in progress. And this is not a sales pitch, by the way. This is just informational. This is what happened. This overall deception was laid bare in 2003 in Cracking the Code. Immediately upon the publication of Cracking the Code, readers began recovering amounts that had been improperly withheld or paid in against potential tax liabilities that they now realized didn't actually arise. And these folks learned what the income tax really falls on, and that in the past they had unwittingly participated in misapplying the tax to their own unprivileged earnings in just the fashion that I had described to you a few moments ago, which unfortunately most Americans continue to do today. Being serious law-respecting American grown-ups, they promptly said no more of that nonsense, because the law says this isn't how it works. The law, you either follow the law or you don't. And if you want to give gifts to the government, go ahead and give them. Don't call them a tax when you haven't done something taxable. Give it to them as just write a check. Say, we love you, and we love everything you do, and do more of it, please, and here's my money to do it with. Do that, but don't pretend that it's a tax. That is law defying. It's not law respecting. The recovered amounts include all normal federal, state, and local income taxes, as well as Social Security and Medicare taxes, which are just income surtaxes. They're income taxes, just like any other, even though they have special names. They're income taxes. Just as wages, as defined in the law, is income. It's just a special name for a special category of income. Educated Americans not involved in withholding situations have simply stopped falsely assessing themselves a tax and cutting checks to the various governments for amounts not actually owed under the income excise. Their hard-earned money never leaves their own pockets. Altogether, as best can be calculated, these now tens of thousands of American men and women have secured complete refunds of everything taken from them on more than 200,000 occasions, totaling more than $2 billion. You can see well over 1,000 documented examples of these at the website listed below, if you're interested. Unfortunately, the people responsible for the lies that we looked at are still scrambling to stay in power and keep their gravy train rolling. But things are getting dicier for them. They're getting dicier for them because you're here listening to me right now, because you're reading these words, because you've just seen the lies, you know the implications. And I'm hoping that you will share that information with everybody you can. This is critically important stuff. This is the Leviathan. Now, if you like Leviathan, that's fine. Some people do. Some people, they don't feel comfortable about having a really big, vigorous, high-energy government, a Hamiltonian state. I personally don't like that. I think that it makes us all more impoverished and certainly makes us all less free. But to each their own. But if that's how you feel, just give it to them. Don't try and perpetuate or allow the perpetuation of a fraud by which it is believed, and it is encouraged to be believed, that everyone is subject to a tax that they really aren't, in order to have your way and have a big government. Just give them your money. Let's see how that sorts out. And a couple of notes of places where more information can be had. I encourage everyone to visit losthorizons.com, the 16th.htm, and get a detailed explanation of that perfect storm that took place in 1943, the details about the history of the tax and the history of the 16th Amendment, and a great deal more, actually, in what really is a fairly concise 25-page paper that I think everyone will find of great interest. And that's all I got on this paper. I want to point one other thing out, though. So give me a moment here while I recalibrate. Just 1 second. I think the camera is running. I want to show you all one other image. And that is this. And the reason I'm showing you this is, I don't know, some will take this as snark. I don't mean it that way. There are a lot of things that are out there injected into the activist communities, your community, that is intended, in my view of more than 30 years of involvement in these activist communities, and many, many years of researching these things, particularly drilling down on notions that pervade the activist communities, checking them for validity and correctness and so forth. A lot of things are injected into this community in order to keep people spinning their wheels, to keep people distracted from or unable to recognize the actual root of the problem. The actual root. There are all kinds of things. There's nothing that a rogue state wants more than for people to be chasing will-o'-the-wisps off into the woods. And then you do not concentrate your power. You do not strike at the root. Striking at the root is what needs to be done by people who want to retain their individual rights, protect themselves, restore the republic. We're up against a very, very well-funded, very, very well-practiced program of deception and control. And you gotta make every strike count. And so I want to address just one of those things because it's one that is unfortunately really, really big in the way of a distraction, and that is the concept that it doesn't matter, they'll just print the money anyway, let's just, hang our heads and, go home and throw a hood over because there's nothing we can do. Okay, they cannot just print the money. The Fed is not the problem. The Fed is not the problem, and I want to use this graph again to illustrate that fact by adding a couple more factors into the picture. I already showed you about what the rate of income tax filing was and about the flat line. Okay, we had overall government, on average, during that entire period of time, consumed less than 10% of America's wealth. Less than 10%, that's government, federal, local, and state, all combined. Okay, we had a small government. Now, by the standards of the founders, that was a huge government. Nearly 10%, that was huge. That was like, they would just be mystified at that kind of structure. To us today, that would be paradise. Yeah. It would be paradise to get down to 9.8% of our wealth, our production being consumed by government. And at the time, for most of that period of time, and particularly at the end of the 19th century, when that was still the case, we were the most prosperous people in the history of the world. Yes, sir. And the freest at the same time. At the same time. Most prosperous, most free. And with the best potential for any person that applied themselves to go anywhere they wanted, pretty much. That was when you really could say to your kids, you can be anything you want. Because you really could. And not so much true today. Today, we're the biggest debtor in world history, this country. That's the reversal that's taking place. And here are the other two factors I want to point out here. All right, this is when the Federal Reserve Act came into operation. And it carries forward to today. Now, you see how that affects in the flat line area? It actually didn't, it made a little bit of a blip. It did. It fattened it up a little tiny bit. Just a little tiny bit. And more significantly, the greenback fiat currency, which was exactly the same sort of thing, except that it didn't have the private component of the Federal Reserve System units in operation. The government printed this stuff directly. But it was the same fiat currency. It was just printed on the printing press, just like Federal Reserve notes are. Exactly the same. That went into effect in 1862. And it remained in effect until 1972. Did you know that? The greenbacks were still in circulation and valid legal tender until 1972? They were. The printing money thing didn't make the difference. They had that. They had that for 80 years before that hockey stick goes up like this. The hockey stick goes up like this when the income tax misapplication scheme began. That's when it happened. That's what caused it. That's the only thing that makes it happen. It is this one thing, the thing that you have just seen, the reality between the excise tax, as it really is, a benign, wonderful tax, and the misapplication of the tax that federal courts are actually prepared now to lie about in black and white overt terms. Something that you will not find about other things. You will not find those kinds of lies told, as much as there's a lot of misrepresentation, a lot of fudging, a lot of overlooking and so forth that goes on in federal courts. You will be hard pressed to find outright lies like what we've just seen about anything else. This is the taproot. The income tax misapplication scheme is the taproot. This is the thing that makes all the rest of it happen. This is where attention needs to be paid, and it needs to be paid to nothing else. If it's being paid to anything else, it is energy being wasted. If you are interested in restoring the Republic, resuming limited government that we have had, shrinking Leviathan back down to the size and status and condition that the founders and framers intended it to be, and that led to us being the most prosperous and freest people in the history of the world for all the years until our parents' generation or our grandparents, depending on how young you are, let it go and made the mistake. They were asleep at the wheel in the mid-1940s, and that's where we're at now. So, okay, that's all I've got in the way of presentation. If anyone has any questions, I'm going to sip a little coffee, and then I will